Good morning. I want to thank you all for being here this morning. We still have a few people kind of flooding in out in the pedestrian mall, but we'll go ahead and get started so we can stay on schedule. I want to welcome you to this year's annual Source to Solution Symposium. We are very excited that you're here, and I see a lot of familiar faces. I see a lot of faces that I want to get to know better, so hopefully we can do that throughout the day. I am Lynette Hollis-Finley. I had the opportunity to work as the Behavioral Health Manager for the City of Lubbock and Lubbock Public Health. We have multiple programs under the behavioral health umbrella that address substance misuse, prevention, and mental health awareness. It is an amazing team that I get the privilege of working with, and you'll meet a lot of them today throughout the day. Substance use and prevention and addiction treatment are especially important, not only to those who work in the field, but also to those in the community, whether they're aware of it or not. It affects all of us in some way, directly or indirectly. According to the Region 1 Prevention Resource Center's 2024 Regional Needs Assessment, there are 56 alcohol-related vehicular fatalities in our region in 2022. This is the second highest rate in the state of Texas. This same report tells us that opioids are the leading cause of overdose deaths in our region, closely followed by stimulants. I think that our area deserves better than hearing about substance use tragedies in the news each day, and the fact that you're here tells me that you feel the same. That's why we have such fantastic guest speakers, volunteers, and vendors here today. Please make sure that you visit each of them in breaks, and at the very end of the day, we'll have a time to network. So, I would now like to introduce you to Catherine Wells. She is the director of the City of Lubbock Public Health Department. Her innovation has helped to establish substance use prevention, treatment, case management services through Lubbock Public Health. She recognized the need in our community and made the decision to provide better access to those in our region. Catherine truly cares about the people of West Texas and tirelessly puts the needs of those we serve first. Behavioral health in Lubbock and throughout our region benefit from the work she does in multiple capacities. If something is going well, you can bet Catherine has a hand in it. Please help us welcome Catherine Wells.
Thank you, Lynette. Welcome, everybody. It's great to be here. Again, this is actually our fifth Source to Solution Symposium. It was started back in 2019. It was the brainchild of Councilman Randy Christian, and it's been wonderful to continue the work in offering this symposium every year. Thank you all for joining us today, and really thank you for your commitment to substance use prevention, treatment, and recovery. An event like this would not be possible without community support and a hard-working planning committee. I want to thank those who were involved with the planning of today's event and or provided financial support. Those include the City of Lubbock, Star Care, Stages of Recovery, the Ranch of Dovetree, the Texas Tech University Center for Students in Addiction Recovery, United Supermarkets, HEB, the LBK Community Network, the Susan Program, the HERD Coalition, our Teen Awareness Group, or TAG. So please give them a round of applause for all of their work. Addressing a public health issue as complex as addiction cannot be done in a silo. It takes collaboration from multiple sectors, including our schools, law enforcement, counselors, our mental health authority, public health, hospitals, community-based organizations, employers, churches, community groups, and then those individuals. And I'm so excited that in this group, I've seen people from Covenant, I see people from the Sheriff's Department, I see public health, I see lots of Star Care employees, and it really takes everybody coming together to make any change in our local community. So the goal of this conference really is to bring all of us together, and I see it kind of as a checkpoint to ensure that we are constantly improving how we do this work and that we haven't become compliant. And I hope everyone in this room can answer yes to at least one of these following questions. Over the last year, have we improved the services that we offer? Are we offering more services than we did a year ago? Are we removing barriers to care? Can people get into the services with the least amount of paperwork and other documentation that's needed? Are we implementing evidence-based strategies? And have we expanded services and resources? If you can't answer yes, then I encourage you to make a commitment to work within your organization to make sure that you can answer yes to one of these next year. Some of the things that we've accomplished over the last year as a community, really exciting things happening. We broke ground for the Hope Center. And if anybody doesn't know what the Hope Center is, it's going to be a diversion center, a place where police or families can go for individuals in crisis. And it's truly an alternative to taking somebody to jail or the emergency room. And the goal of it is to provide those wraparound services to help an individual so that they don't enter the criminal justice system. That groundbreaking is at StarCare, and it's going to be on that campus. The Lubbock Public Health Department, or Lubbock Public Health, has actually opened our new building. If you haven't come and seen it yet, please stop by. We have enough room for all of our substance use services to be under one roof. We also have meeting space and different places where we can start offering more services. And then our school district is now offering training on how to respond to overdose and risks of illicit drugs. I'm really excited that Lubbock ISD has partnered with the Houston Crime Stoppers to offer an evidence-based curriculum to all middle and high school students. So this is really going to make an impact across our region. And although we are making improvements, there is still a lot of work to do. And I encourage you all to take the things you're learning today, the ideas and networking with individuals, really to improve the services available in our community. I also want to take a few minutes to talk about some work the Public Health Department's doing. Last November, we started the process of a community health assessment and a community improvement plan. And the goal of that plan is really to formalize the work of the Public Health Department, raise awareness of the health needs in our community, and strengthen partnerships to address health issues. One of the areas that's included in this plan is really a focus on improving access to substance use disorder services. When we started this process, when we started the process of the community health assessment, we really wanted to get information from the community. So we had key informant listening sessions of over 25 individuals in our community, and we talked to everybody from the CEO of a hospital to somebody that's receiving social services. We really wanted to get a broad range of feedback and information from members of our community. We also held community engagement sessions to hear what the health needs were of our community, and then we conducted a community survey that had over 3,000 responses from individuals in Lubbock County. And then from this data, we're working to develop a community health improvement plan. The improvement plan is a strategic plan for both what the city can do to improve health and then also how we need to work collaboratively to improve the health of our community. This report was approved by the Lubbock County Board of Health in October, and we will be taking this report to Lubbock City Council and the Commissioners Court in December. And the public health priority areas that we will be focusing on include access to health care. So this is both access to acute health care, primary care, but also access to substance use treatment, medications to help treat individuals. Another focus area is to continue all of the work we're doing in the community around mental health in partnership with StarCare and Texas Tech, but then also really doing a focus on substance use and how do we ensure that we're also increasing access for substance use disorders in addition to individuals with mental health disorders. We're also looking at a focus on chronic disease. We'll also be addressing sexually transmitted infections. Lubbock has some of the highest STI rates in the state of Texas and also in the United States, and we really need to do work to curb those increases. And then the last one's looking at coordination of information and services. So how can we gather better data, better information about the health needs of our community and get that to the right individuals who can make decisions about how to improve the health of our community. So I'm very excited about that work. I'll let everybody know when those go to City Council and Commissioners Court. We may need some support when we do that. Well, anyways, I hope everybody has a great day here. Please enjoy. Please make sure you get lots of food and coffee. And with that, I'm going to turn it back to Lynette.
Our first keynote presenter today will be Judge Mark Hocker. Judge Hocker has been the judge of Lubbock County Court at Law Number 1, a court of general jurisdiction, since December 21st, 2011. He primarily hears Class A and B misdemeanors, family law, and matters involving competency and mental health, plus a few probate, estate, and guardianship cases. Judge Hocker graduated from Texas A&M University in 1995 and Texas Tech University School of Law in 1998. He practiced law for 13 years as a prosecutor, criminal defense attorney, and civil litigator, and tried more than 200 felony and numerous misdemeanor cases to juries before taking the bench. Judge Hocker is active in the Lubbock Area Bar Association, the Lubbock Lions Club, and First United Methodist Church. He has been happily married to his college sweetheart, Heather, since 1996, and they have a beautiful daughter, Mary Elizabeth. Please welcome the Honorable Judge Mark Hocker.
Okay, while that gets going and we get technical stuff, hey, look at that. And I was a little younger when that picture was taken. I think that was 13 years ago. As she told you, I'm a lawyer. I'm an Aggie and a Red Raider. I have a daughter at the Cult of Orange in Austin now. My shame. But I'm very proud of her. She's doing great. I am not a mental health treatment provider. I am not a substance abuse treatment provider. I like to think that I'm an influencer in that way, not an internet influencer. I'm not dancing on TikTok, I promise. But because of the work that I do in the courts, I like to say, encourage people to get help and assistance with their mental health problems, with their substance abuse and use problems and addictions. And sometimes we have more encouragement than other times. But this is an area of law that is very important to me. And just so you understand, my court is a court of general jurisdiction. County court at law, we hear criminal cases, misdemeanors that put you in jail. DWIs, prostitution, thefts, mischiefs, possession of marijuana, lots of marijuana, certain low-level drugs, Adderall, that kind of stuff, not cocaine and methamphetamine. That goes to the district courts. We don't put people in prison. We put people in the Lubbock County Jail. We hear civil cases up to $250,000. I don't do a lot of civil. We have a local agreement where we divide that up. And then we have probate, estate, and guardianship jurisdiction concurrent with our constitutional county court, which of course is helmed by Judge Curtis Parrish. So he hears a lot of that stuff, but we hear it in the county courts of law as well. And then when people are suggested to be not competent to stand trial, which we will talk about at length here today, I hear all of those cases for the district courts and the county courts at law. Our regional presiding judge cross-appoints all of our district and county court at law judges to hear cases for each other, which is really handy if somebody is pleading out on a misdemeanor and they're dismissing a felony. I can sign that felony dismissal for the district judge, or they can hear my misdemeanor plea. We can cover and help each other out. And we try to not step on each other's toes. We really work well together. But when anybody is suggested to be not competent to stand trial, they come to me. and they go on my docket, and I shepherd the case through the competency evaluation and restoration process until we get them restored and returned to the district court or any other court that they came from, or we go down a different road, and we'll talk about all of that. I am not trained in this area. I actually have an undergraduate degree in architecture, like most lawyers, right? But I went a different way after architecture, and I went into law and then went into criminal law. And lo and behold, I found lots of people with substance abuse problems and mental illness problems. So I'm going to talk to you today about the role that the court plays in dealing with mental illness. The cases that come to our court primarily are going to come to us in two different ways. One, civilly, where we're going to look at some kind of a civil commitment, and we're going to talk about that at length. Or on the criminal side, we once in a blue moon have an insanity case, and I'll tell you about that a little bit, and some cases you've heard of that make sense out of that. And then we deal a lot with competency restoration. We know that substance abuse and mental illness are associated with crime, especially substance abuse. And you have direct crimes as result from substance abuse because, of course, possession of most of those substances is illegal, or the overconsumption of them. So DWI, public intoxication. Of course, selling the drugs is illegal too. And frankly, most of the cases that I've seen involving endangering a child where it's a neglect, and it could be elderly or disabled as well, is oftentimes a result of substance abuse disorder because they're not taking care of the kid because they're too high, and they're too high all the time. Or it could be because of mental illness. But as you know, a lot of other crimes are connected to substance abuse and use. These are going to be our property crimes where they can't hold down a job because of what they're doing, or they don't want to, but they steal to get money to use their drugs. So lots of property crimes. Domestic abuse, sadly, and much more on the alcohol side than on the marijuana side. And then, you're very unlikely to get killed by a stranger in Lubbock County, Texas. Most of our murders are in the drug trade. And it's one drug dealer killing another, and ag assaults as well. And of course, human trafficking, prostitution, all of that stuff is connected. So the crimes matter. And all of these things, some point, can end up in the courts. And I've told you why I'm here to talk to you about that. When we talk about mental illness in the court, we don't talk about all forms of mental illness. We primarily focus on what, under the DSM-4, would have been called Axis 1 disorders. Schizophrenia, bipolar, schizoaffective, that nasty combination of schizophrenia and bipolar together. Major depressive disorder, not just general depression. It's got to be major. It's got to be impairing the ordinary functions of life extensively for it to come into our consideration in the courts. PTSD, boy, that is really becoming something we're learning more about every day. We're learning better about how to accommodate it, treat it, and deal with that. And then intellectual disability disorder. Now, IDD has changed. We don't say the R word anymore. That was the terminology in the medical lingo, even under the DSM-4. That was the terminology. And one of the big things, if you can't see this, I'm sorry, I tried to make it big for you. But under the DSM-4, we had a number, IQ, 70 or below. We don't have that under the DSM-5 anymore. We talk about deficits in intellectual functioning, in adaptive functioning, the onset of these problems during the developmental phase. What that really means is we need to diagnose you with IDD before you reach 18. And we catch these in our public schools mostly, but some people get through. Occasionally, I get people in my court who are well beyond the developmental age. They could be in their 30s, and somebody's saying, well, I think they have IDD, and they've never been diagnosed, or we can't find the records from their diagnosis. If they grew up in another state and they've lost touch with all their family, we don't even know what county. Sometimes, imagine dealing with a guy that's voluntarily mute who can't tell us anything about himself. And he probably came into jail on a trespassing charge. And now we're trying to figure out what's going on and where do you even begin to start to get those records? It's very, very difficult. You would also be surprised, maybe you wouldn't, y'all work in this field, how difficult it can be to get records out of the federal government. I have a case right now where the guy is 100% disabled and receiving Social Security disability for intellectual disability disorder, and they won't turn any of those records over to us. And we're trying to determine what to do with them going forward. And boy, if we just had those records, wouldn't that be nice? But he's too old. He's way beyond the developmental phase to just go back and reliably test for IDD. So this is problematic. And when we look at IDD, we don't just say, well, he's under 70, that's it, we're done. That's just a factor, but they can be mildly IDD, moderately, severely, and profoundly. But it's all a gray area, and it ultimately comes down to some expert looking at them and saying they're okay, they're low functioning, but they're functioning, or they're not. And we look at it. Things that we don't consider in the courts include senility and dementia. Now, that's absent some other co-occurring mental illness. I mean, you can have a mentally ill person who then goes into senility and dementia. We're going to worry about the mental illness side of that thing and not the other. Alcoholism, generally, and there are ways that the courts get involved in dealing with alcoholism through all the collateral things, but not alcoholism itself. And I will tell you, I'm not going to cover this in this presentation, but I'm going to mention there is in Texas law a substance abuse commitment where a court can commit somebody to inpatient treatment involuntarily, court-ordered, because of alcoholism or substance abuse disorder. I don't think I've ever seen one in 13 years on the bench in Lubbock County. I never recall seeing one as a lawyer. I've talked to other judges from all over the state. It is just rarer than hen's teeth to actually see it. And I've known people that probably needed it. It's just not something we do very much. So it's something that exists under the law. Maybe we should be doing more of it. That's not my area to talk about today, and that's not my lane to go into as a judge either. If that case comes before me, I would certainly consider it. I am versed on the law of that, but it's just not something we see much. Depression, again, we do consider major depressive disorder, but not depression otherwise, and not just that, catch-all general mental deficiency. It really needs to come into a diagnosed type of illness before we can really consider it. And for the purposes of diagnosing, we use the Diagnostic and Statistical Manual of Mental Disorders, or what we call the DSM-5. Now, to understand what we do, I think it's important to understand where we came from. How did we get to where we are today so that you know what page that we're on? Because a lot of times people look at the headlines. Why did that happen? Oh, I love it when people look at the headlines and say, why did the judge give that guy that sentence? Well, it was probably a plea agreement, and we didn't even know anything about the facts of the case. Our job is to say, does it fall within the law? Is it agreed to by the parties, and nobody's making anybody do this? But of course, we're the ones that went easy on them or hard on them or whatever else. Usually we don't know anything about it. So let's look at how we got to diagnosing mental illness. In World War I, this spanned 5 years, what happened when these soldiers, and remember, the United States did not enter the war until April of 1917, so we just participated in the last 2 years of World War I. But what happened when these soldiers started coming home from the war? Something was wrong with them, and we didn't know what to call it. It was clearly mental illness. It was probably PTSD. We would certainly recognize that today, but that wasn't a term that existed at that time. We said that they were shell-shocked. 1917 was also the first year that organizations in America began to gather uniform mental health data from our hospitals. This was the first attempt in America to start cataloging mental illnesses. This was followed a few years later by the American Medico-Psychological Association, the forerunner of what became the American Psychological Association, publishing their nomenclature of disease and conditions. And this was the first American publication that really tried to start cataloging mental illnesses and how we diagnose them and coming up with some criteria in that regard. The focus here on treating them at this time was purely through psychoanalysis. We didn't have drugs. We just were going to use psychoanalysis, and that would be the model for decades to come until things changed. Well, World War II happened, and again we have soldiers coming back with shell shock, and the U.S. Army got involved, not just the Army, but the Army was one of the leading organizations in trying to help its soldiers that were coming home with problems related to the combat and the trauma that they saw. And they started cataloging and doing things, and the World Health Organization followed on the heels of the work by the United States Army and published a list of mental disorders themselves. And yet it still took another decade until we get the American Psychological Association publishing the first edition of the DSM. The DSM-1 comes out in 1952, and this is the first time we get an official classification system for broad use by people practicing psychology and psychiatry all across America. The prevailing view at this time, and understand this is what the courts have to follow too. The prevailing view is that mental illnesses are reactions to psychological, social, and biological factors. We revised that 16 years later, the year I was born. So this is not ancient history. This is my lifetime. I was born in 1968. Some of you were born before that, in the 50s, right? This is within living memory. We removed the idea of this being reactions, mental illness being a reaction to these factors, but the factors were still causative, and they were still incredibly important. And interestingly enough, although we were doing this here in America, other places in the world were not. We always, have that egocentric view of the world that what we're doing is the standard of the world and everybody's following us. They were not. In fact, in 1970, a study was conducted comparing diagnoses in New York and in London. And what they found was the exact same symptoms presented were being diagnosed and people were being hospitalized under different diagnoses, specifically looking at schizophrenia and manic depressive illnesses. That was 1970. It still took 10 years later until the DSM-3 came out in 1980, where we got a widely accepted method for diagnosing, classifying, identifying symptoms, and the DSM-3 was accepted across the world. England, America, Europe, everywhere. Everybody said, this is a good way to do it. We're all going to get on the same page. And this was probably a good thing. The DSM-3 also introduced for the first time a multi-axial diagnostic model. And I'm going to talk about more in the DSM-4, which followed 14 years later in 1994. The DSM-4 is still in our colloquial vernacular. We talk about Axis 1 diagnoses. I've already mentioned it one time myself. We replaced the DSM-4 in 2013. 11 years ago, we're still talking about this 1994 Axis 1 model. And you see on Axis 1, these are the things I mentioned earlier: schizophrenia, bipolar, schizoaffective disorders. And then there's other things that aren't as controlled. There's 5 axes under the DSM-4. And they are clinical disorders, the Axis 1 diagnosis that the courts are primarily concerned with, personality disorders, general medical disorders, psychosocial and environmental factors, and then a global assessment of functioning. This is a diagnostic model. If we look at every one of these axes, look at all the factors involved, it's going to help us get to a good diagnosis. At least that was the theory that started in 1980 under the DSM-3, and then it really got kicked up a notch under the DSM-4. And that global assessment of functioning was really neat because it's a 0 to a 100 scale, something we're all familiar with, like having an IQ thing. And on that scale, I don't know how well you can read it, but you had to be below 50 to have serious impairment. You had different degrees of impairment. But how nice was it to have a factor? Well, we abandoned all that and threw out all the multi-axial diagnosis models when we came out in 2013 with the DSM-5, and that is still the current standard. There was a text revision in 2022, and they made some very minor changes, nothing significant. But we threw out the multi-axial model, and we said instead we're going to look at classification, and we listed all the official mental diagnoses and what they are, the disorders. And then we listed a criteria set. This is really important. If we're going to say this guy has this, remember that 1970 study where in England they were manic depressive, and in America, in New York, they were schizophrenic? Or vice versa? Shouldn't we all be on the same page? Shouldn't we have a set of criteria that all professionals look at and say, this meets this? And significantly, we also had rule outs. So they got to have these symptoms, these criteria, but then they can't have these other things. That makes even better and more precise diagnoses. And then we came up with very descriptive text so that if you say, well, I'm a professional, I'm thinking about diagnosing them this way, and I've got these symptoms, and I've ruled out these other things, and then you look at that final description and say, does this description meet the person that I'm looking at here? So it's a good model. I think it's good. But we're still learning things. I told you there was a text revision in 22 just last week in the Cell Reports Medicine Journal. So I'm sure you all read Cell Reports Medicine, right? Just good stuff. But the Tufts University, just last week, published a thing where they found that we know schizophrenics struggle with uncertainty. If you ask them to make a decision and throw a bunch of options out at them, they don't respond well to that. And they theorized, and through functional magnetic resonance imaging, where they can look at the brain lifetime and look at the connections, they found that the connections between the cerebral cortex and the thalamus were not working right in schizophrenics. And so they through scientific imaging, they said somebody who is struggling with uncertainty and making decisions, that is a potential symptom and a diagnostic tool for diagnosing schizophrenia. So we're just learning more and more every day. Just a few years ago, I was at a national mental health conference, and several doctors were presenting, and one of the themes that they all kept saying is because of functional magnetic resonance imaging and the ability to look at the workings of the brain in real time in response to stimuli, we've learned more about the human brain in the last 10 years than we knew for all of human history before that time. So this is still a really new and emerging field. But here we are today in this world where our first responders are our frontline mental health people. I mean, when somebody on the streets is struggling, and it could be substance abuse disorder, it could be mental illness, or most likely co-occurring problems, who's getting called? 911 calls. Who comes when we call 911? The police. Are these guys mental health professionals? They're becoming that way too much. We've talked about the diagnostic history and how we've gotten to where we are, but let's also look briefly for a minute at the treatment history. My profession, the law, I mean, the Code of Hammurabi, the earliest biblical scriptures, the earliest scriptures of every religion have got rules for how we're supposed to act as a civilized people. Law is an old profession. Math and science, go back to Pythagorean, go back to Archimedes. Old stuff, been around a long time. Medicine, I mean, probably since the first caveman stubbed his toe, we've had medical treatment of some kind. But psychiatry is really, really new. In fact, in America, we didn't even recognize it as a medical specialty until 1844. And recall, it was 1917 when we first started gathering uniform data to try to come up with some. And it was 1921 when we first published a book on it. And we started having a nomenclature of diseases related to mental illness. So this is a really new thing. Remember, I mentioned 1844, first recognized it as a specialty. In 1841, a lady named Dorothea Dix, she was a teacher, and she went into the jail to try to help people. Really nice. She was going to go teach Bible classes in the jail, but what she found in the jail was terrible conditions, and she wrote a letter to the Massachusetts legislature, and she said that what I saw in the jail is we're keeping people in cages, closets, cellars, stalls, and pens, people that are chained, naked, beaten with rods, and lashed into obedience. She lobbied the Massachusetts legislature to treat the mentally ill better. Not just mentally ill, everybody in jail, but especially the mentally ill. And her efforts worked to establish or expand over 30 different institutions to treat the mentally ill. And of course, that sign was honoring her. And so even though we first established hospitals for the mentally ill in the 1773 was the first hospital in America. It wasn't until the mid-1800s and the work of Dorothea Dix and some others, of course, that we really begin to see these hospitals take off. But does this look like a nice, good place to put people? That's an actual picture from an 1800s lunatic asylum. Here's an example. In 1833 in Worcester, Mass., we built a psychiatric hospital with 120 beds. It became so successful that 13 years later, we had 400 beds crammed into that same square footage. That was a mess. By 1955, we had nearly 500,000 people involuntarily incarcerated in mental institutions around America. That's also about the time we peaked in the institution of the mentally ill in America. And these places were intended when they were first conceived, and certainly what Ms. Dix would have wanted was to be safe and therapeutic places where people with mental illness could get treatment and get help and live quality and productive lives. But as they became overcrowded, as they became unfunded, as they became that place out of the way that we don't want to think about or look at, things got worse, and they became terribly overcrowded. I mean, you can see here just the hallway lined with beds. That's not any way to treat human beings with dignity. World War II, it didn't get any better. Remember, a lot of doctors and nurses and staff were drafted. They're off fighting the war, and we've got extra people coming back with shell shock, with terrible PTSD problems and other things. This is the Yosemite Naval Hospital. This is how we treated our sailors who served our country. We packed them into rooms like this, and this wasn't a good thing. And ultimately, our mental asylums, our mental hospitals, these places that should have been kind places to treat people with illnesses, became much more like jails and prison. That wasn't a good thing. And then something magical happened in 1954. The wonder drug. Well, that's what the marketing wizard said it was. The wonder drug, Thorazine. This is going to cure everybody. And it got approved by the Federal Drug Administration. It's going to treat schizophrenia. It's going to treat bipolar. It's going to treat schizoaffective disorder. Isn't this great? We're not going to have to lock people up in asylums. And we're going to be able to return them to the community and just medicate them. And it's going to cure them. We know how that worked out. That was followed a few years later by President Kennedy signing the Community Mental Health Act of 1963. By the way, this was the last piece of legislation that he signed before he was assassinated. President Kennedy had a special interest in the mentally ill and mental health because he had a little sister named Rosemary who was born with terrible mental illness problems and seizure disorder. And her father, Joe, had her lobotomized as a young adult woman. That was state of the art at the time. I'm not blaming Joe for doing that, but that was a procedure fraught with terrible risk. And unfortunately, Rosemary was left unable to speak and unable to communicate and was warehoused for the rest of her life in secret and in hiding. And the Kennedy family didn't really talk about her. But our president, he knew about his sister. He cared about her. He said there's other people in America like this. And he wanted to do something. He wanted to invest in institutions that would help people and help people move into the community. This was followed just a little bit later by the creation of Medicaid. And Medicaid, together with Thorazine, is going to take the money needed to pay for the drugs and help the people move from these inpatient, involuntarily custodial mental institutions into the community where they can be treated well with this wonder drug. And wouldn't that be great if the money actually followed them and if the drug actually worked? But what happened is we closed our mental institutions. The drug didn't work, the money didn't follow, and we left with people living in mental health deserts where they didn't have access to treatment. It was far between. And that wonder drug, Thorazine, it had some really nasty side effects. Besides not curing people, it made them worse off sometimes. Dizziness and salivating and akathisia, which is like this restlessness that they don't like. Some other drugs that we came up with had a really nasty thing called gynecomastia, where men grow boobs. Men don't like that. That's not a great thing. Chest pain, tachycardia, palpitations, dyspepsia, all sorts of things that people didn't like. So they don't want to take, even if this medication worked, they don't want to take it because of what it does to them. And there we are. Our jails have become our mental institutions because the people wear out their families, they wear out their communities, they don't want to take the drugs because of the side effects. If the drugs work and they feel better, then they feel fine, and then we don't need the drugs anymore because, hey, I'm fine. And when they're not fine, of course, then they do get involved in some kind of criminal activity. I mean, I feel so bad for the guy that's just trespassing at the 7-Eleven because he wants to talk to Jesus in the ice cream freezer. How do I tell that guy you can't do that? But the 7-Eleven doesn't want him in there. Dirty and smelly and peeing on the floor or whatever else he's doing, they trespass him and he doesn't leave and the police get called. Today, the largest provider of mental health services in Texas is the Harris County Jail. That's shameful. Jail should not be the provider of mental health services, but they end up there and we have to deal with them. So let's talk about when they come to the courts and what the role of the courts is. Primarily two ways, civil commitments and criminal cases. Let's talk about civil commitments for a minute. When the police get that, when that 911 call comes in and the police have to go and respond and deal with somebody on the street, they've really got a couple of options. One, they can seek mental health services for the person. And thank goodness StarCare is opening that new facility and we're going to have that great drop-off place and police are going to have a better option for taking somebody to the hospital instead of to jail. So let's talk about when they take them to the hospital in the way that we go. And what we're talking about is civil commitments. And the word commitment implies it's a court order telling somebody they have to do something. They didn't choose this voluntarily. If they were voluntarily willing to go in for treatment and services, we wouldn't need the courts to be involved. So there's two ways that they can be taken in on civil commitment. We can have an emergency detention by a peace officer or a magistrate's warrant for emergency detention. Emergency detention by a peace officer requires that the officer find that, one, the person is a person with mental illness, not something else. They got to actually have mental illness. That doesn't mean the officer has to have diagnostic skills. They need to have some idea to figure out this person has mental illness. And because of that mental illness, they are substantial risk of serious harm to themselves or to others unless immediately restrained. This could be as simple as this person's going to walk out into traffic. And I've got a lot of cases where people walked out into traffic, sometimes naked, sometimes inviting people to do things because they're not right in the head. That is a danger to themselves and others, but they can be a danger to themselves and others in a number of ways. On an emergency detention, then the officer takes this person into custody against their will. They're going to handcuff them for officer safety, put them in the car, and they are to transport them to a mental health facility. There is a caveat for taking them to a jail in an emergency when there's no other alternative, but mostly they're supposed to go to a mental health facility. Likewise, somebody, an officer or any family member, any concerned person, a doctor could come down to the courthouse and find a judge and get a magistrate's warrant for emergency detention. It's the same standard. I will tell you, there are some judges in Texas that don't want to issue emergency detentions. Their reasoning is, and some of them have been taught this by a judge who teaches a lot in Texas, that, well, if it was really an emergency, the officer would have detained them. If you had time to come down to the courthouse and see me, it's not really an emergency. I disagree with that. I think what we have is the law provides multiple avenues for resolving a problem. The judge does have to find it is an emergency type situation, but that doesn't mean that they couldn't come and see us. And what we find a lot of times is they call 911 in crisis, and the officer often doesn't get a whole lot of information. But before they come to the courthouse, they find the papers with medical diagnoses. They bring other information with them, and they come see the judge to get that warrant. So we often, at the courthouse, see a lot of different information than what the officer is provided on the street at the time. But we still have to find, before we can issue that order, that there's a substantial risk of serious harm to themselves or others. There has to be a very specific description of what that risk of harm is. It can't just be vague. And it can't be the kind of thing where, well, they went off of their meds and, a month ago when they went off the meds, it got really bad, but nothing's happened yet. That's a factor we could take into, but is that emergent? Maybe. Are they going to get bad in the future? Maybe. But it's got to be bad now before a judge can actually issue that order. The judge's issuance has to be based on specific recent behavior, overt acts, attempts, threats, and there has to be a description of what these are. This is a problem that we run into as judges a lot because we get what I call conclusory statements. Well, he does bad stuff. Okay, you can't tell me that. You got to tell me what he actually did. Tell me when he grabbed the knife and he pointed it at you. That's a specific thing, not just a vague thing. We run into the same problem with search warrants when somebody says, well, they drove badly. Okay, that's not enough. You pulled them over for violating a law. Did they weave outside the lane? Did they speed? What was it? You can't just say they drove badly. They drove recklessly. Now, there is an offense called reckless driving, but you need to tell us what was reckless about what they did. Well, if they're swerving and there's another car next to them and they're almost hitting it, that's reckless. But that's fact-based. We got to have facts. The magistrate can review the application that's presented. There is a written form. We have that in our Office of Court Administration on the 3rd floor of the Lubbock County Courthouse. And the judge can interview the applicant and ask questions about what is presented. Ultimately, the statute says the magistrate shall deny the application unless finding reasonable cause. What is reasonable cause? Now, you have to have reasonable suspicion if you're a law enforcement officer to pull somebody over or to detain them when they're going about their business. And that reasonable suspicion has to believe that they've committed a crime or they're about to commit a crime or they're in the process of committing a crime. You got to have probable cause to arrest without a warrant. I have to have probable cause to issue a search warrant or an arrest warrant. A jury has to find proof beyond a reasonable doubt before they can convict. In other situations, we talk about clear and convincing evidence, which is more than probable cause but less than proof beyond a reasonable doubt. But what is reasonable cause? I love it when the legislature just writes this stuff into the statute like we know what it means. It's not really defined anywhere, but it's probably somewhere between reasonable suspicion and probable cause. They just kind of made that up. They got to have a substantial risk of harm. Again, this can't be, well, I think they might do bad stuff in the future. It's got to be right now. It's imminent, it is substantial, and it is serious harm. Coyote's fixing to fall off the cliff right there. That's pretty good. He wandered out in traffic. Ultimately, on that emergency detention, we want them to go to Sunrise Canyon Hospital here in Lubbock, Texas, or the equivalent somewhere else. And they can only be detained for 48 hours. Within the first 12 hours of reaching the mental health facility, they have to be evaluated by a physician. Notice physician does not mean psychiatrist or psychologist. That means medical doctor. They have to be examined by a medical doctor who has to determine they are appropriate to be admitted or they must be released from that facility. And there's rules about if they get released, you got to transport them back to where you found them or where they live or another place that would be appropriate where they will be safe, which all too often is Salvation Army or Grace Campus or something like that. Within 12 hours, they're going to be examined by a physician, and then they can be held for up to 48 hours. There is an extension on that. If that 48 hours ends over a weekend, you've got up until 4 o'clock on the first business day after a weekend or a holiday. Then, while they're being, this gets very confusing, y'all. While they're being held on an emergency detention for 48 hours, somebody can file an application for court-ordered mental health services. This would be temporary in the beginning. Later, subsequent applications can be for an extended purpose. This can be filed by a county attorney or a district attorney without a certificate of medical examination, or any adult with a certificate of medical examination. We see a lot of times where they go to Sunrise Canyon on an emergency detention, doesn't matter whether it's officer or magistrate, and then Sunrise Canyon files the application and they include a certificate of medical examination with it. There is a caveat. They cannot be charged with a criminal act involving a threat, an attempt, or an act of serious bodily injury to another. Serious bodily injury, not simple assault, serious bodily injury, but even a threat, and we can't hold them on one of these kind of applications. They're going to unfortunately just have to go to jail if they're dangerous and they have a criminal charge pending. We're initially going to file the application and seek treatment for 45 to 90 days. Should be 45 unless the medical people say it has to be longer, and then it can be up to 90 days. We're going to appoint them an attorney within 24 hours. We call it an attorney ad litem. That attorney's job is to look out for their interests, make sure their rights are protected, make sure the government's not just throwing them in the hospital or the jail and locking away the key. That ad litem has to argue on behalf of their patient. I will tell you, that's a difficult job as a lawyer when your patient's not right and your patient wants something that's not good for them, and that's the argument you have to make. And that's different from an amicus attorney who might be a friend of the court who might just say, well, here's what we need in general. An ad litem has to argue on behalf of the patient. Sometimes those are silly arguments, but they have to be made. That person has the right to be represented, even if they're not quite right in the head. And then, if the application is filed, we must set it for a hearing within 14 days. But some other things are going to happen in the meantime. And remember, that emergency detention only holds them for 48 hours. So what happens in the intervening 14 days? Well, we can file a motion for protective custody. And this is a frustrating one because we have a motion for protective custody, we have a probable cause hearing, and then we have an order for continuing detention. All of those result from the same filing. I wish they would have the same name, but I didn't write the law. So the motion for protective custody can only be filed after that application for court-ordered mental health services is filed. So they got to be detained under emergency detention. They could go in there voluntarily. We do have people that go voluntarily to the emergency observation unit at Sunrise Canyon and then decide they want to leave, and Sunrise Canyon's like, oh, and then they go get an emergency detention. And then somebody files the application for temporary court-ordered mental health services that'll be heard 14 days later. In the meantime, then we have this motion for protective custody that is filed. It can be filed by the county attorney or the district attorney, or actually a judge. A court can file it of its own accord if they have reason to believe that. I don't know why a court would at that point, unless maybe they've been reviewing the application. They again have to be appointed an attorney. It's going to be the same attorney that was appointed as the attorney ad litem on the application. And we got to have a hearing within 72 hours. So we have a little window of problem since the emergency detention holds them for 48, and this thing has to be heard within 72. There could be a gap where they get out. We hear these a lot quicker than 72 hours. We try to hear them within that first 48 hours. The standard here that the court's looking at is probable cause. The state does not have to call any witnesses. They can rely on the application itself. There does have to be that doctor's report where they had to be evaluated 12 hours after going in and determined that they were sufficient. Here, the standard is that the judge hearing this probable cause hearing must find an adequate factual basis for probable cause to believe that the person presents a substantial risk of serious harm to themselves or others if they are released. Then they have to remain at liberty. Notice what you didn't hear in here was deterioration of the ability to take care of yourself and function. But I think if the case was made factually, not conclusively, but factually, that a person is deteriorating in their ability to function and care for themselves so much that they present a substantial risk of serious harm to themselves, then that would fall under that prong. But just deterioration of that ability to function alone is not a standard to keep holding them, and they would have to be released, and now they're out free in the world until we get to that hearing 14 days later on the application for court-ordered mental health services. But if the judge finds probable cause to believe that they should be held, then they can be held until the hearing on the application. So we get to that hearing. Remember, it had to be in 14 days. That can be extended, but not longer than 30 days. Not longer than 30 days for any reason, anytime, anywhere. And it only can be extended or continued, as we say in the court world, on a showing of good cause. So we're going to have to do that pretty darn quickly. It's generally going to be held at the courthouse or any suitable location. So we do oftentimes go and use a conference room at Sunrise Canyon Hospital to do hearings. We have also done them in the jail or other places where we need. The person has a right to be present at this hearing, but they don't have to be. They can waive that, or their attorney can waive it. If they do, it has to be on the record. This hearing is open to the public. Oftentimes we do them in rooms where the public is not there, and it would be difficult for the public to be there, but the public has a right to be there, and we need to respect that. Zoom has made that easier. We can send anybody a Zoom link if we're doing it via Zoom, or we just have to find another way to make sure that the public has access to it if somebody wants to be there. In order to grant the application for court-ordered mental health services, the court must hear competent medical or psychiatric testimony unless they waive it. The individual or their attorney can waive that if they want to. Rules of evidence do apply at these hearings, so we can't just have the state introducing a police report. That would be hearsay, not allowed. The rules of evidence do apply, and this is a hearing done on the record, so we have a court reporter there taking this down. Here's what the state has to prove to get this 45 or 90-day court-ordered mental health services order. They have to prove that the person has mental illness. So now we're talking about a diagnosed mental illness, not just a suspicion of they ain't right. We've got to prove mental illness. We've got to prove a substantial risk of serious harm to somebody, to themselves or somebody else. We also can have this standard of they're suffering from severe and abnormal mental, emotional, or physical distress, experiencing substantial mental or physical deterioration of their ability to function independently. That's a really long paragraph. There's actually more to it than that. I shortened that. That's what we call that deterioration of the ability to function. But that's going to have to be pretty dang significant. Not just, well, they're not eating as much as we would like them to eat, and they smell kind of bad because they're not bathing as often as they should. It has to be impairing them significantly, endangering their health, and they're not able to make an informed decision about whether to submit to treatment or not. Again, all because of that mental illness. The standard of proof at this hearing is clear and convincing. This is more than a preponderance, which is just more likely than not. It's more than probable cause, which is closer to a preponderance. It's not proof beyond a reasonable doubt. But it is clear and convincing. It has to be based on expert testimony unless that's waived. We have to have that recent overt act. Not, well, they did something in the past and I fear they might do it again. I can't tell you how many times I see that in the court. Somebody wants to get that emergency detention, or the application is based on, well, we've known this person for a long time. They're a person known to us. And, 2 years ago, they went off their meds and it got really bad. That's not enough. That is historical. That is a predictor of what might happen in the future, but it has to be imminent and happening right now. That's not enough to say that it might happen in the future. We can consider non-medical evidence if a family member or somebody else wants to testify as to what they've seen. Oftentimes that recent overt act evidence comes from somebody who's not a mental health professional. They're somebody that first witnessed the dangerous act that got them detained, got them in the hospital. Sometimes they've continued to have activities while they're in the hospital. They have a right to a jury. Okay, I want you to think about that for a second. Do you know how long it takes us to get a jury? 14 days is not enough time to send out summonses and get a whole lot of people there. So that is one that might be continued for more than 30 days. What's really going to happen is we're going to bump another case that was set for trial because we have to hear this now. We don't have an option to wait longer. We can't make them pay a jury fee. Of course, they have the right to have an attorney and everything else. If they waive jury, they have to do it orally in open court and on the record with their attorney. Their attorney can waive it for them. And they have to, if they want to then back out of that. We do see people that waive jury and then come back, no, I do want a jury. They must do it 8 days before the trial setting or they can't do it. We don't see juries in those cases very often. And then we have the hearing. We've talked about having that. I think I've covered everything on that. Let me move on. Ultimately, if we grant an order for court-ordered temporary inpatient mental health services, that can be inpatient or outpatient. Outpatient civil commitments seem kind of odd. We're ordering somebody, you get to live at home. It's like putting them on probation. You're going to go see your doctor. You're going to take your meds. You're going to come to court when you're supposed to. You're not going to take the street drugs and alcohol that you want to take. You're going to take the good psychotropics. You're going to stay away from persons and places that might cause you to fall off or get into bad shape. That's usually not as big an issue as you might think. And you're going to go see the treatment providers and comply with whatever they tell you to do. Most of the time, these are going to be inpatient commitments. At the mental health facility, Sunrise Canyon, or a state hospital, or some entity like that. But we can do outpatient services. It's difficult. The same standards apply. And frankly, I will tell you, we should do outpatient commitments where they're workable, because it is absolutely more respective of a person's rights. It's absolutely that right to be free, first of all, and to determine where you live and where you work and what you do. They're going to be for 45 days unless there's reason to make it for 90 days. And then, of course, we can come back later. One other thing that we can do that oftentimes we do at the same time, we finish the hearing, we grant the application for court-ordered mental health services, and then we roll right into a compelled medication hearing because the person is not taking the meds that they need. We don't want that. And I can't tell you, I bet you 50% of the time at the end of the hearing, if I look at the person and say, if I order you to take the meds, are you going to take the meds? And they go, okay, I'll take the meds. And I say, well, I'm going to give the order anyway. So if you don't take the meds, they're going to hold you down and they're going to inject you. But we'd really rather you take the pills, because if you take the pills, we can control the dosage a lot easier. We can titrate up to a level that is sufficient to treat you. We know that can take time for those medicines to level up and start taking effect. But if we have to give you a shot, then you have to give you a long-acting injectable, and it's kind of unfortunate. And there's more side effects to some of that. We have some things that are not available in shot form, and you might respond better to one medicine than another, but that medicine you respond to might only be in pill form. So we try to get them to take the pills. And like I said, at least half of them, knowing that a judge is going to order it and they're going to get the shot in their arm whether they want it or not, then they'll agree to go ahead and take the meds. And when they take the meds, they get better most of the time. And then they become very pleasant to deal with, and we enjoy them, and that's nice. These are probate matters. As a county court at law judge, I have probate jurisdiction. Because the other judges in Lubbock County are cross-assigned with me, they can hear these kind of cases for me. So Judge Parrish could hear it, I could hear it, any of our district judges could hear it sitting for me. And then we will issue the order if it needs to be issued. And we'll issue the compelled meds if we need to issue them. We don't want to do compelled meds if we don't have to, but if we have to, we will. I also wanted you to know there are consequences to a finding of mental illness, and people worry about this. Well, if I'm adjudged not competent, if I'm adjudged to be committed. And by the way, if you ever notice on applications for different things now, it'll say, have you ever been committed to a mental institution or something like that? It doesn't say, have you been adjudged not competent, but have you been committed? But what it doesn't do is it doesn't disqualify you from voting. You can be adjudged mentally ill and committed to a facility and still retain your right to vote, to acquire, use, and dispose of property, to enter into contracts, to sue, and to be sued. Yes, the mentally ill can enter into contracts and they can sue and be sued. You might have some issues if you're on the other side of one of those lawsuits, proving that they freely, knowingly, and voluntarily entered into that contract and they knew what they're doing. They have the right to obtain licenses and permits. Their legal privileges are not removed from them. They still have the right to choose religious freedom. That's different from being under a guardianship order, for example, where the guardian gets to decide where you live and who you date and what church you go to. Guardianship is terribly, terribly restrictive, and so we try to avoid guardianship at all costs. And we can have limited guardianships. We have guardianships of the person and guardianships of their estate. It's one thing to say they can't manage their money well and someone needs to look after it so that it doesn't get frittered away. It's another thing to say they don't get to decide where they live and who they date and who they worship. That's pretty severe. So we look at these different things. Okay, so we've talked about civil commitments for a minute. I want to talk about now what happens when 911 was called, and instead of going to Sunrise Canyon Hospital, they went to our jail and charges got filed. Ultimately, if they're a person with mental illness, there could be two things. They could file a notice of intent to raise the insanity defense, or they could raise the issue of competency to stand trial. I'm going to talk about insanity for a minute. First thing I'll tell you, it's rarer than hen's teeth. I think I saw one insanity case in Lubbock in the last 2 years. They're just not very common. But the way the insanity defense works is you have to prove that the person has a mental disease or defect of the mind, Could we just say mental illness? They got to have a diagnosed mental illness. And because of that, they don't know the nature of what they're doing, or that they don't know that what they're doing is wrong. If you have those two things together, then it exculpates you from responsibility for the act you have committed. Here's one of the nasty things about it. You have to admit you did what they said you did. So if they said you killed your kids by drowning them in the tub, you have to admit that you held their heads down under the water until they suffocated and drowned. But then you say, but I did that because I was mentally ill. I didn't know what I was doing. I thought they were demons and I was drowning the demon, not my child. I didn't even realize I was a child until later. I was so mentally ill and I was only acting because of that mental illness. The insanity defense arises from a case involving McNaughton in England. And we call it the McNaughton Rule. In 1843, he set out to murder the Prime Minister of England. But he murdered the wrong guy. He found a guy named Drummond, and he killed him thinking that was the Prime Minister of England. He was tried and acquitted by the jury by reason of insanity. He pled insanity. I didn't know what I was doing. And the jury bought it, and he was acquitted. Well, this really upset the British legislature. And so they conducted an investigation into this. They called in physicians to testify in front of the House of Lords. Now, remember, this is 1843. We hadn't even recognized psychiatry as a medical specialty yet in America. I don't know if they had yet in England or not. But they had people that knew something about it, probably just ordinary physicians. And they came up with the McNaughton Rule that you are not guilty of a crime if at the time of the event you didn't know what you were doing or you didn't know that what you were doing was wrong. Interestingly enough, the rule that they came up with would not have served McNaughton well at all because he was trying to kill somebody. He just got the wrong guy. He still knew that killing was wrong. He didn't fail to perceive the consequences of his act. He just shot the wrong person. Big deal. So you have to admit you did what you did factually, but you just didn't understand what you were doing, or you should be excused because you were so mentally ill. And ultimately, you end up with if it works successfully, you get a finding of not guilty by reason of insanity, or NGRI, as we abbreviate it. So you've heard of this defense. It's kind of rare, but here's a few famous cases that'll help you understand it better. Remember John Hinckley? He tried to assassinate President Reagan. He was schizophrenic. He shot Reagan and 3 other people. He was found not guilty by a jury. He was committed to a psychiatric hospital. That was 1982. Interestingly enough, he was released in 2022 and went home to live with his mom because the court found that he was no longer dangerous. They're only committed for so long as they're still dangerous, and these things get reviewed over time. Here in Texas, 2001, Andrea Yates drowned her children. She claimed that she was not guilty by reason of insanity because of postpartum psychosis. She had a trial. It went wrong. They tried her again. At the second trial, she was found not guilty by reason of insanity, and she was committed to the state hospital. As far as I know, she is still there. You might remember the American sniper, Chris Kyle, who was killed by a guy named Eddie Routh, and who was put on trial in 2015. He testified he thought Chris Kyle was a pigman hybrid, and he was killing a pigman hybrid, not a human being. But the jury didn't buy that. They convicted him of the crime, and that's usually the way we see it go. In fact, it's terribly unsuccessful. In Texas, the insanity defense is raised in less than 1% of all criminal cases, and it is only successful a quarter of the time that it's raised. So in 1/4 of 1% of the cases, the insanity defense works in Texas. Interestingly enough, it's more successful in England. As much as 15% of the time in homicide cases, it is successful. It is raised, whereas less than 1 in Texas, 15% there. And it's successful up to about 4% of the time in England. Although, for some reason, Ireland, in homicide cases, it is 23 times more likely to be successful in Ireland. I don't know what's going on there. They bite off on it a lot more than we do. So it is an affirmative defense. It has to be pled and proven. This is one of the only times when the defendant in a criminal case in America has to prove something. Otherwise, the burden's always on the state, never shifts to the defense. But when you raise affirmative defenses, you assume a burden to prove something. You have to file notice of intent to raise it. You have to give the other side notice. You have to submit to examinations, including by the other side's experts. So now you're not getting to hide anything. And then the experts that do the examination, their reports go to both sides. It's not like the defendant can have his expert examine him and never tell the state about it. It doesn't work that way. We get the reports. The experts have to be psychiatrists or psychologists. We can use psychologists, which are PhDs, in these things. And then if the defendant won't submit to examination, the court can order them to. And ultimately, if they won't do it, then they may not get to prosecute their defense. The experts have 30 days to turn their reports in. Oops, that doubled that side, I'm sorry. If they are found to be not guilty by reason of insanity, by a jury or by a judge, then we next have a dangerousness hearing. Is this a person who's dangerous? Like Hinckley, not guilty by reason of insanity, dangerous, kept him locked up for 40 years. He's out now because we keep reviewing that. We have 30 days to get that done. And then the court will retain jurisdiction over that case. It doesn't go to the Department of Criminal Justice, Institutional Division, or anybody else. It actually keeps coming back to the court, and every year we have to review that commitment to see if they're still needing to be locked up. And we can have another trial. There can be motions to modify to say, well, now they're less dangerous. We can move them to a less secure facility. We can move them to a halfway house. We can move them to a outpatient commitment at their home or somewhere else. And they have a right to a jury trial. They have a right to a jury trial up front. They have a right to a jury trial on a modification at a later time. In the remaining time left, let's talk about what I deal with the most, which is competency to stand trial. This is where they went to jail instead of the hospital, and they have been determined they're not okay to proceed with trial at this time. Insanity relates back to the time of the offense. I didn't know what I was doing then at the time of the offense because I wasn't right in the head. I have a mental illness and it was impacting me to where I didn't know what I was doing, or I didn't know what I was doing was wrong. But competency says I'm not okay now. I can't go sit in court. I can't assist my lawyer. It says that I lack the present ability to consult with my attorney and have a reasonable degree of rational understanding. That's the ability to make a reasoned choice is what that really is, a reasonable degree of rational understanding, and that I lack a rational as well as factual understanding of the criminal proceedings. So competency restoration involves two things. One, we've got to get them right in their head where they can make reasoned choices, consult with their lawyer, understand what's going on, and we educate them about the process so that they have a factual understanding of the proceedings, the role of the judge, the prosecutor, their attorney. In determining whether they are competent to stand trial or not, we're going to consider their behavioral history. That could include suicide attempts. But while we may look at other factors, they are not determinative, such as do they have good speech? Can they speak well? Are they well behaved in the courtroom? Do they have delusional thinking or not have delusional thinking? Just because they don't have it right now doesn't mean they don't have it at other times. It's wrong for a judge to just look at a guy and say, well, he looks okay in the courtroom now. No, let's look at the experts, see what they say, and see how everything else is. You've all probably seen cases of the mentally ill where they can, say, pass for a while until you get close enough, and then they tell you about their friend the dog who talks to the bird and tells them what's going on in China, or something else that's, like, wow, that's delusional. Competency matters. Sometimes people don't understand why we spend time on competency, and it's expensive, and it delays the prosecuting cases. But we don't believe in trying people in their absence. You got to be present to be tried. Well, if you're not present up here, you're not present. We need to get you present. And this is consistent with criminal law and contracting and everything else. We don't let people say you signed a contract when you weren't there to sign it or when you didn't know what you were doing. You got to be present. The process is pretty simple. Somebody raises the issue. The court can raise it on their own motion. I have done that when I've had somebody appearing in front of me. Judge Brummets here, I'm sure he has done it too. You will just have people in front of you that are saying things that don't make sense, and you assume that they are deluded or something's going on. They need to be evaluated. Usually it's their criminal defense lawyer that comes in and says, Judge, I can't communicate with my client. Like, I keep telling my client something and they aren't getting it. They are off the wall. They're talking to the toilet angel and the light bulb angel and everything else, and we need to have them checked out. We order an examination. We use psychologists for this primarily. It could be a psychiatrist. They go and meet with the person. They also look at the police report, any prior medical records that we have, the medical records that the jail has, how are they acting there as well, any other information that they can get. And then they send us a report back. And ultimately, they're going to say the person meets criteria to be found competent to stand trial, or they do not. If they do not, then the question is, well, could we restore them? And most of the time, most people are probably restorable. Can't predict the future for certain, but we got to try. And then we'll put them into the competency restoration process. If they do not meet the criteria for restoration, then we sometimes get a second opinion. The defendant has a right to get a second opinion in secret. We call that ex parte. The state can request a second opinion that everybody sees. The defense can request a second opinion that everybody receives as well. And ultimately, we can have a trial. Most of the time, it's a bench trial. Oftentimes, these are trials not on whether they need to be restored and found not competent at the moment, but where that restoration should take place. Is it going to be inpatient at the state hospital or in our jail through our jail-based program, or could we do it outpatient? And obviously, outpatient, we're worried about where are they going to live. How are they going to get to their treatments? Are they going to stay on their meds? Are they going to be dangerous? Is anybody going to be put in danger? Are they going to be a danger to themselves in that situation? If they can be treated outpatient, that's great. But they got to be here in the county. They got to be able to do all that, and we got to keep everybody safe. If they go through the restoration process and they go through the treatment and the education, a whole lot of it is medication. 80+% of it is getting them on the right meds, getting them off of the street drugs. At the end of the process, we have them evaluated again. And the issue now is not did they get better from where they were before, it's are they competent? It's the same exact standard. They meet the definition or they don't. If they meet the definition and everybody agrees, we sign an agreed order. If not everybody agrees, we have a contested trial. The doctors testify, the court or the jury makes a determination. We move on down the road. If they are not competent and not restorable to competency, either up front or after an attempt at restoration, then we look at civil commitments as I discussed before. I see that I just have a couple of minutes left, and I want to lastly tell you the courts are innovating through the history that I've told you about. You know this is a young field. We're still learning things about psychiatry. We're learning about mental illness. We're learning about that co-occurring mental illness and substance abuse and how they work together. I'll tell you, one of the most difficult things is when we have somebody that's terribly addicted and terribly mentally ill, which one do you treat first? Do we put them through drug rehab when they're not competent or mentally ill? Or do we try to fix that while they're dealing with addiction problems? And it is a case-by-case basis. It's what's available at the time. What does this person need? There is no rule about which one that we do first. We just take them up as a case-by-case basis. But the courts are trying to innovate. One of the things that we're seeing arise now is mental health courts. These are problem-solving courts. They're like drug courts and DWI courts, where you have a judge, you have a prosecutor, you have a defense attorney, you have team members, you have counselors, you have medication involved. But a criminal case is pending. It can be pre or post adjudication, meaning they could have to plead or not plead to go into the court. But it's basically like super probation, because they're going to be on some kind of supervision and they're going to come to this court. We're going to move them through phases and step them up. If you want to know about these courts, Judge Brumman is here. He was a founding member of our DWI court when he was on the DA's office, and now he runs that court. And he can tell you a lot about how a DWI court, which is the same as a drug court, works. We don't have a mental health court in Lubbock, but we're looking at it. We're talking about forming one right now. The other thing we have is outpatient assisted treatment courts, or AOT courts. These are not necessarily for the criminally involved. These are for the people that keep taking up hospital beds, keep coming back to our facilities, to our emergency rooms, and to Sunrise Canyon Hospital. And if they just had some accountability and some follow-up treatment, maybe we could keep them on the same path. And we're looking at this as well. We're trying to see, and these are two different tracks. You know, one is criminally involved people, the other one is not. And they have to be competent to go on one of these programs, but the idea is that we can reduce their need for services and help them live a better life with just a little bit of an accountability through a step-up type of program. Ladies and gentlemen, that's it. I think I've covered everything, and I'm out of time. I will stick around to answer any questions individually, but thank you for your attention and time. Enjoy the conference.